Good morning, everybody. Thank you so much for joining Anne Corrigan and I. My name is Soila. I'm from the divorcemagazine.co.uk, and I'm the founder and editor of that magazine. It's an online magazine for people going through divorce and separation. And today we have Anne Corrigan, and I'll let Anne Corrigan introduce herself, and you can tell us what you do, Anne.
Hello, good morning everybody. My name is Anne Corrigan from Clarity Family Law Solicitors, and we're based in Gerrards Cross in Buckinghamshire, but we look after people all over the place, and we're specialist family lawyers, so the whole remit of family law comes under our roof.
Okay, and could you just tilt your screen a little bit, and then so we can see your shoulders, because the other way. Yes, perfect. Yeah, that's much better. So, and today, on the Divorce Magazine, we have a lot of information about divorce and how to divorce, the divorce processes, and what one needs to keep in mind, and looking at it from a financial perspective as well. Bringing in family mediation, and you are a family mediator also, aren't you?
Yes, I am.
Yeah,
Yes.
but one of the things that we haven't looked at, and I know it's a big topic, for a lot of people when their relationship is a bit rocky and they're thinking of, leaving. One of the questions they have is, what are grounds for divorce? Because they ask, do you have grounds for divorce? Can you tell us a little bit more what
Yes,
grounds for
certainly.
divorce stands for, what it entails?
Certainly. So, Soila, the only ground for divorce in this country is that the marriage has broken down and that the breakdown is irretrievable. So, in other words, there's no going back. It is irretrievable. It's not going to be saved. There's no prospect of a reconciliation.
Okay.
So, the ground is the irretrievable breakdown.
I see. Okay.
That's the only ground.
Okay.
But then we have what are called the 5 facts,
Okay.
and they're set out in the Matrimonial Causes Act, which is this huge piece of legislation that governs divorce and the separation of finances. Everything to do with divorce is contained in that Act of Parliament, which has been around since the early 1970s.
Okay.
So, having established that you consider the marriage has broken down irretrievably, you then have to rely on one of the 5 facts, and they are adultery, which is, I think most people know, it's having a sexual relationship with somebody that you're not married to whilst you're married. So adultery is the first fact. Unreasonable behaviour is the second, and that's by far the most commonly used fact in divorce. Then we have separation, 2 years separation by consent, which means that if you have lived separately and apart for 2 years, you can base your divorce just on the 2 years, providing the other person is going to agree and consent to a divorce on that basis. The 4th ground is separation of 5 years. And that's rarely used. That's sometimes used when perhaps your husband or wife has disappeared and you can't trace them, but it's not very often needed. And the 5th ground is desertion, which in 33 years I have never needed divorce on the basis of desertion. So the unreasonable behaviour and the adultery and 2 years separation are by far the most commonly relied on facts to support the ground of irretrievable breakdown.
Okay, interesting, because we used the 5-year separation because we'd been separated for, I think it was probably 5 or 6 years, and there was nothing to contest and argue about, and it worked really well, but that was 5 years.
Yes.
Now, if we go back to number 2 for the unreasonable behaviour, first of all, I like that difference that you made with regards to irretrievable, well, you know the word, irretrievable breakdown, of your marriage, that is that is it, and then you break it down into the 5 bits. So if you go to unreasonable behavior, what does that entail? What does it look like?
So the legal test for unreasonable behaviour, effectively you have to prove, and people get upset about the word prove because how do you prove it? But it's all done on paper. The whole process is a written process. You very rarely would have to go to court, if ever. So you have to prove to the court that the behaviour you're alleging is such that it's made it intolerable for you to live with the other person.
Okay.
And so effectively it's anything that you find unreasonable. It's a subjective test. So what you find unreasonable and what I find unreasonable could be two completely different things. But the test is subjective, and if you found it intolerable to live with the other person as a result of their behaviour, then that constitutes unreasonable behaviour for the purposes of divorce.
Can you give us some examples of what, because I'll tell you why I'm asking, because I remember when I was going through my first divorce, and one of the things that the solicitor said was unreasonable behavior could be anything.
Yes.
And the example he said was it could be the fact that he's squeezing the toothpaste from the wrong end, or just squeezing it as opposed from whatever other people do with it.
That's right.
Yeah,
That's
and
exactly
he said
right.
that could actually be something that I could say I can't live with this.
Yes, yeah, exactly, and that's the point. If
Wow.
it's intolerable to you to continue living with the other person. So I often find that the grounds of behaviour differ, obviously, if it's the husband or the wife. And wives complain of maybe feeling a bit isolated, maybe their husband spends all his free time on the golf course, maybe he works very long hours, doesn't socialise with his wife, doesn't spend enough time with the children. And lots of women say, as a result, I feel worthless, my confidence is depleted, I just can't live like this anymore. I don't feel he loves me anymore, I don't feel we have that closeness, I've tried to chat to him about it, he refuses to discuss it. So all of that would constitute behaviour. Some people think that unreasonable behaviour has to be extreme, so
Yes.
there has to be domestic violence,
Yeah.
or maybe, I don't know, an alcohol or a drug dependency. But very few people are in that situation. Well, not very few. I mean, obviously there are people in that situation.
Yeah.
But by far and large, it is much more simple stuff that people rely on, the sorts of examples I've given.
Yeah.
But obviously, if there is something dreadful like domestic violence, or maybe somebody is drinking too much and the relationship just doesn't work, well, obviously that would be something you could rely on. I think it's important to remember it's subjective, and so I often give the example when clients ask. I will say, some people might say, "Oh, my husband's never at home, he's always on the golf course, I never see him." And other people will say, "My husband never leaves the house, I'm sick to death of him because he never leaves the house." So what's unreasonable and intolerable for that
One
person wouldn't be for that person. They'd be glad if he was on the golf course all day, or if she was out shopping for the whole weekend. So it's very much subjective.
Okay, so let's say in an example, I come to you and I say, this is the reason why I want to leave. I can't be with him anymore. I'm really lonely. He's spending all his time on the golf course, doesn't see the children, doesn't help out. If he's not on the golf course, he's down the pub with his friends, and he doesn't come with me when it's family functions and so on and so forth. So to me, that's the main problem that I'm having. So I come to you and I say, this is it. What would you suggest somebody does next?
So if somebody is absolutely at the end of their tether and they have really made the decision that they cannot go on any longer, they want a divorce, then I always try and take the heat out of it.
Okay.
And I'll come to why that's important. So normally I would give them full advice, obviously, and tell them what they need to be looking at, not just in relation to the divorce, but a lot of people say, what about the children? People think that there are custody orders, which there aren't, of course, and the financial issues are major because it's a huge upheaval. It might involve the sale of the family home, or one person moving out and so on. So I will give the person lots of advice, tell them what their options are, and also tell them what the process is. Because most people, when they first come to see me, want to know how long it's going to take.
That's right.
And what it's going to cost.
Yeah.
And so obviously you deal with as much as you can on the first occasion. And then I would suggest that I write to the other person. So if I'm being instructed by a wife, I will say, well, look, I'll write to your husband and just say that unfortunately you consider the marriage to have broken down, and just set the scene. But the important thing is this: when drafting the particulars of unreasonable behaviour. It's human nature. Some people want to say, and he did this, and she did that, and a whole list of things that they've done wrong. And I always say, don't do that. Don't approach it like that, because there's no point in increasing the temperature. Let's keep it as friendly as we can, because especially where there are children, you don't want two people to be at loggerheads. And so my advice always is keep the particulars of behaviour as brief as possible and as anodyne as possible, as inoffensive as possible. Don't upset him or her more than is necessary. And occasionally I might see a divorce petition that has got pages of allegations of behaviour. It's just wrong.
I think I can relate to that, because I think that's one of the things that I did when I was going through my first divorce. And because you're so angry and you want to just vent. And my solicitor at the time was absolutely brilliant, because he acknowledged this maybe 5-page letter I had written, and by hand, Anne. That's just to show you where I was. And he acknowledged it, and and the way he did it, it felt like, oh, okay. He never brought it up. He never used it. Nothing about it was just put there. Thank you very much for this. And I just thought, oh, okay, I've taken. But he didn't use it. He didn't fan the flames of my anger, and which really,
is the right way to
exactly, it really is the right way to do it. And I think that's what some people are afraid of when they go to see a solicitor. They're afraid of because there was another one that I saw, and she was going to do whatever she could, to make it the most acrimonious divorce she has ever handled, with the second one. But I think that's important to note, that it doesn't have to be that way. I'll stop it here, because I can see then we'll go into part 2. And in part 2, there are 2 things. I want to continue talking about the unreasonable behavior, but I also want to bring in emotional affairs, when people get emotionally attached and they have relationships, online or with somebody on Facebook or something like that. What does that mean where does that fall? And also the custody issue that you mentioned before, because there's always a question around child custody when you're going through divorce, that I think not many people realize exactly what it is and what it isn't. Yeah? Okay.
Great.
All right.
Lots to talk about.
Be right back.
Okay.
Hello, everybody. Thank you for joining Anne and I in part 2 of Grounds for Divorce. And we are looking at exactly that. What are grounds for divorce? And my name is Soila, founder and editor of the divorcemagazine.co.uk. And Anne Corrigan, just tell us again where you're from in terms of work.
So I'm Anne Corrigan, and I'm from Clarity Family Law Solicitors. We're based in Buckinghamshire, but we look after people everywhere, and we're a specialist family law practice.
Okay, and it's good actually now when you say we look after people everywhere. I think that's the beauty of what the world has become so small. So you can work with anybody anywhere. Like you can work with them on Skype, on the phone. They don't have to come to your office anymore. No. Okay. And we were just looking, we've dealt with unreasonable behavior, some aspects of it, and we've looked at what to do next when this is the situation that you find yourself in. And again, one thing that I'd like to bring back again is the fact that, and it's something that we try and do a lot on the divorcemagazine.co.uk, and it's to put out that point that it doesn't have to be acrimonious, it doesn't have to be angry, and there are ways of going around it, without making everybody fight each other. It doesn't have to be that way. I think it depends very much on the support that you have as well, and who your solicitor is, and family mediation and so forth. One thing that I wanted to ask you, I think if we just look at the child custody part, because there are always questions around that, where even today I know some close friends or people who are going through divorce, and one thing they say is that I'm going to fight for full custody.
Yes, yeah.
Yeah. So can you tell us a little bit about that? Because I think there's some misunderstanding in that area.
I think there is. So the word custody disappeared from the law in 1991.
Thank goodness for that.
14th October 1991.
All right. To be precise.
Yeah, when the Children Act of 1989 came into force. So we got rid of the whole concept of custody, and because it used to be that one parent would get custody or maybe joint custody, and then the other parent would get, and they'd have, it was used to be called care and control, and the word is even inflammatory. You know, why would one parent have control, and the other parent would have what was called reasonable access? So that disappeared when the Children Act came in 91, and it was replaced with the concepts of residence and contact, on the basis that really the child or children could only really live with one parent. So a residence order said this is where the children are going to live, and a contact order said and the children will spend time with the other parent. And, you know, the court could make orders. But since 1991, there has been what's called a non-intervention principle.
Okay.
So the court will only get involved with children arrangements if it's a last resort, if you know, the parents just can't agree. So that was until very recently. And then in April of this year, there's been two changes this year. In April, the government introduced what are now called child arrangements orders.
Yeah.
And the child arrangement orders very much put both parents in control of what happens, and we don't talk about, we used to have orders that said the resident parent would allow the children contact with the other parent. So it's a really wrong message, because they're both parents.
Yeah.
So child arrangements orders came in April, and they now say the child shall spend time with one parent and spend time with the other parent. And so it might be that the child spends time with the mother, let's say, from Monday to Friday, and spends time with the father on alternate weekends.
Okay.
Wednesday night and so on. So it's much more about having both parents involved.
Yeah.
And that led to another change, which only came into force on October the 22nd. And that's...
this year?
Yeah,
okay.
A few weeks ago, 2 weeks ago. And we now have Section 11, to be boring, of the Children and Families Act, now talks about parental involvement. And so there's now a focus, and a correct focus, that both parents should be involved with the in the child's life, unless there's a risk of harm.
All right.
So it's really grown. It's come full circle. Both parents should be involved.
What I like about what you're talking about is that it seems to be putting the child in the center of it all.
Yeah,
it's not
exactly.
it's not what mommy wants or what daddy wants. It's what is good for the child, and I think that's a huge step forward.
Isn't it? And it's what mummy and daddy think is best for the child.
Yeah.
Not, you know, mum says this, dad says that.
Yeah.
And I think it's a huge and, you know, fantastic provision that's now come into force, because everybody will now know, oh, well, I can't stop her seeing the children, I can't stop him seeing the children. The law says that we've both got to be involved. And how could that be wrong, really?
Yeah, exactly. And that's the other topic that I try and you know, talk about in the divorce magazine. I hope with what you're talking about is going to become more of a rarity, and that's parental alienation, which is and also just when people pick up and leave. I've had, you know, emails from people who have picked up my, you know, the free ebook I have online, and they say, well, you know, it's easy for you to say, you know, you're divorced, get over it and move on. The fact is I can't move on because I haven't seen my children for a year.
No,
you know, so that is something that I hope, you know, the new October, what's it called? Children?
So it's Section 11 of the Children and Families Act.
Yeah.
2014, and it talks about parental involvement unless there is evidence that a child would suffer harm if they had involvement from one or other of their parents, but that's so rarely the case.
Yeah, okay.
And Soila, you know, when people are hurt and they're angry by the breakdown of the marriage, it's very easy to let that hurt and that anger affect your judgment with the children. And that's what the law is trying to get rid of. You know, it's not about you, it's about the child.
Yeah, like I always say, no parent becomes a bad parent overnight.
No, I say that too.
Yeah.
And when people say, and she did this and she did that, or he's done that, well, actually, you were married for 20 years and he was a perfectly good father. So actually, let's not go down that road.
That's good. Okay, the other, thanks for that. Thank you. That's really important. I think I'd like to, talk about that a little bit more at some other point, the section 11 and the whole children and divorce side of it.
Yeah.
The other part I wanted to ask you about, which is something you mentioned right at the beginning in part 1 when you were talking about the 5 grounds. I guess I can call them grounds.
Yes, that's fine.
Yeah. Was adultery. Now, what has been happening recently when I go into children's forums, when I go into parent forums or moms or dads and so forth, there's always this, even on telly when you can hear people talking about it, where they talk about the emotional affairs that people can have.
Yes.
So whether it's, somebody, a husband picks up emails that a wife has been exchanging with her ex, and they can be quite intimate, or text messages and so on and so forth. Now, where would that fall? Would it fall in adultery? Because you clearly said it's sexual adultery. So where would that emotional affair fall?
So that would come under the unreasonable behaviour heading. So because you might consider it's unreasonable that your wife is exchanging intimate text messages or emails with someone while she's married to you. So that would be unreasonable behaviour as opposed to
adultery.
Adultery, Adultery is specifically sexual intercourse with someone that you are not married to whilst you're still married.
Okay, all right. Just one last comment before we finish. I have this thing about domestic violence needing to be completely separate, because it's such a serious thing. It's such a big topic for both men and women. And I find it almost, this is me talking from a non-legal, it's just my own. I find it kind of trivializes it when it comes under unreasonable behavior, because I see it even worse than adultery, because you're physically or emotionally hurting somebody else on purpose.
Yes. Absolutely shocking, totally unacceptable, whether it's a man or a woman. And you're right, it happens to both. And you can rely on it as a ground for divorce, obviously. But there are also lots of remedies for domestic violence. Again, there's a whole huge Act of Parliament that gives you remedies if you are the victim of domestic violence. And there are amazing organisations and charities and support networks for domestic violence. It is never acceptable, obviously, to put up with domestic violence, and there are lots and lots of people out there to help.
Okay.
But in the legal process, you can obtain orders to stop the person from coming near you. You can obtain orders so that you are allowed to occupy the house. You should never suffer domestic violence. Get help immediately. There's lots of it out there.
Okay. And if anybody wanted to contact you, could you just tell us what your website is? But don't give phone numbers, just website and email if you want.
Yes, certainly. Well, our website, which contains a lot of information, Soila, and it's about trying to help people. If I wanted to be a rich lawyer, I wouldn't be doing family law. I'd be doing corporate law.
True.
So I'm always happy for people to telephone. And some people say, it's far too trivial. Well, don't be afraid. There's lots of help out there. But our website is www.clarityfamilylaw.co.uk. And as I say, we're based in Buckinghamshire, but I've got clients in New Zealand, Australia. So you don't need to be near Buckinghamshire. And we're here to help, and there are always remedies available. So don't suffer in silence.
Okay.
Always take advice.
Thank you so much, Anne. Thank you.
Well, you're welcome, Soila.
All right.
Lovely to talk to you this morning.
Thank you so much for coming on.
Okay, bye-bye now.
Bye-bye.
Bye.